count 6, count 3, you may delete despite the proceeding with that count.
Chichizike phambi kwenkundla uchazela inkundla into malunga ngezimangalo ummangalelwa bemangalele ngazo ummangalelwa.
The position is really can be summarized as follows. We are here to move a bail application in terms of Section 60 of the Criminal Procedure Act. The matter was postponed the last time for 7 days. And if your worship goes to the charge sheet, annexed to the charge sheet of the 4th of January when your worship was seized with this matter, page 2 of the notes there, it says Mr. Gordon appears for accused, state is opposing bail. And there was a dispute as to the schedule. Insisted that it was a Schedule 1 matter because the charge of arson appears in that schedule. Anyway, that postponement was, as I say, for the 7 days that is referred to presumably in Section 50 of the Criminal Procedure Act. Hence, we are here to move the bail application. But the documents, Your Worship, that I will refer you, I'm not sure if there are any friends of the necessary copies. I know that 2 of the documents, or at least one was given to your worship in chambers. And for the record, the first document is a purported additional count in terms of the Protection of Constitutional Democracy Against Terrorist and Related Activities Act. And there's a suggestion of a contravention of Section 5 of that Act, which is Act 33 of 2004. I will not read it into the record. Your Worship is in possession of the copy.
Kodwa ke mangalela ke lapha phambi kwalenkundla ke liyachaza into bangaba ke ewe ke ityala liyalaniswa ke umsukela mhla we-4 January lemiselwa ke insuku ezisixhenxe ukuthi ke umangalela kuzojonga ke iinkcukacha zam malunga ngamatyala bawunawo ngaphambili na. Kodwa ke into bafumanisileyo namhlanje bethe befika benkundleni banikwa ke licala lozotshutshiso ke amagqwetha amathathu. Ngoko esithi ke ucala ke lenkundla ke imnike ithuba into bangaba bakhe bathethe ke nomangalelwa ngezinto ezinjabanye lamaphepha bathe bawafumana ngezinto izinkcukacha ezikolo maphepha. Ngoko ke kuloo nto ke bafumanisa into bakhona ke nesimangalo esinye esiye songeza kwizimangalo umangalelwa amangalelwa ngazo.
The next document, Your Worship, is a certificate in terms of Section 6011 Big A of the Criminal Procedure Act, signed by the acting DPP of the Western Cape, Advocate Bell, to the effect that the offense, the new offense, let me call it that, of terrorism is a Schedule 6 offense. Of course, Your Worship will know that that offense actually appears both in Schedule 5, it is the last offense referred to in Schedule 5. It also is referred to in Schedule 6 as one of the cluster of offenses that is there. Now, the implications of that, Your Worship, on the bail application that we intend to move is obviously that it will have an impact, and the purpose of issuing such a certificate in any event is intended to communicate to the court that what we are dealing with is now a Schedule 6 offense, and the legal implications of that go to the onus that has to be discharged.
Avoke kota lichaza into bangabanye manje ukathola bakumenyeke ukufandelwa ngelicala le-DPP apho adokotela apho ke ngongezeke esinye case mangalo ubonakala sisimangalo esinokuzaza kakhulu esa kwaye loo nto sisichaphakezela malunga nesicelo sikamangalela ke sebheyili apho loo nto ithetha ukuthi ke umangalela ngokuza bejongene netyala kuthiwa ngu-Schedule 6 apho
The Worship is well aware, but just for the record, that Section 11 Big A bracket C of the Criminal Procedure Act says whenever the question arises in a bail application or during bail proceedings, whether any person is charged or is to be charged with an offence referred to in Schedules 5 or 6, a written confirmation issued by an Attorney General under paragraph A shall, upon its mere production of such application of corporate proceedings, be prima facie proof of the charge to be brought against that person. And the further implications of that, Your Worship, the real implications for the purposes of the current proceedings would be in subsection, in 11A, section, which says Schedule 6, the court shall order that, or rather, notwithstanding any provision of this act, when an accused is charged with an offence referred to in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, produces evidence which satisfies the court that exceptional circumstances exist which, in the interest of justice, permit his or her release. In other words, that section is an exception to the ordinary rule, as the Worship knows, that an accused person is automatically entitled to bail unless the state can show that it is in the interest of justice to keep that person in custody. The last thing I want to say about that at this stage, Your Worship, before we consult, is that the mere production of these documents indicates clearly that the state is fully aware that what we are about today is a bail application, because otherwise all these documents which are furnished in terms of Section 60 of the Criminal Procedure Act would not have been necessary. And in any event, as I indicated earlier, they indicated as long ago as the 4th that they wanted the Section 57-day postponement of a bail application. Maybe for the sake of completion, without taking up much time, I should just refer your worship to Section 50 itself. And the specific section is 50 bracket 6 bracket D. And that's where this magical 7 days came from. It says the lower court before which a person is brought in terms of this subsection may postpone. In other words, a person who is brought to court for the first time after the 48 hours may postpone any bail proceedings or bail application to any date or court for a period not exceeding 7 days at a time on the terms which the court may deem proper, which are not inconsistent with any provision. And your worship did grant an order last week for the 7-day postponement. So there can be no doubt as to what the issue is today. Then, Your Worship, if I can then move to the third document that we're finished with this morning, less than an hour ago. And this one is even more surprising because I actually had predicted that they were going to bring a charge that fits with Schedule 5. But what I did not predict was that we're going to be given this document, the third one. I'm not sure if we managed to get a copy. Oh, I seem to have an extra copy. I beg you to hand out. In the previous hearing. Thank you, Worship. Thank you, Worship. That document, Your Worship, well, small wonder then, Your Worship, because the document is dated the 3rd of January, which means that it has been in the possession of the state for almost a week now. But that document is purports to be from a Dr. Zelda van Tonder, whom I understand is either from the office of the district surgeon. And in a nutshell, it indicates that the accused was taken for mental observation by the state as long ago as the 3rd of January 2022, which is last Monday. And that there was a diagnosis of so-called paranoid schizophrenia. Apart from the audacity of producing this document at literally after the 11th hour, we obviously have to canvass all these documents with the accused. So, in a nutshell, Your Worship, the position is as follows. The defense is, for the reasons that I've already outlined, here to continue with the bail application, and which the state has indicated it will oppose. And the new document in respect of the alleged mental capacity or incapacity of the accused will, at least indications were given to us that the state will then be applying for the committal for a 30-day observation, which we will oppose. And in any event, maybe let me qualify that statement. We'll oppose it more particularly in relation to, insofar as it may be alleged that it must automatically mean that the accused must remain in custody. So that is the position, Your Worship. I'm not now moving the application, neither is the state, but we just wanted to place on record where we are and effectively to request, Your Worship, if you would kindly stand the matter down. We will indicate, we will make sure that it doesn't take too long, and we will indicate when we are ready, and Your Worship will then be called. If my learned friends have something to add, or they can maybe confirm some of what you said. And the state has no objection to the request. That's correct.
There was an argument between myself and my then friend regarding the schedule. He was adamant that it was schedule 1, the state argued that it was schedule 5, and the state indicated that we would obtain the necessary certificate from our acting director of prosecutions at the Big Bell.
Chuchiske uyaphendula malunga ke ngokuthethe ke ngqotsha apho esithi ke ngalalini ke umdlalo wayevela phambili kwehamba lefunda ityala lalingamiselanga kholisele isebhili balimisele kuba kwakukho impikiswano phakathi kwabo malunga ngetyala ummangalelwa amangalele ngalo.
Or directly noted in the report that the matter was being postponed, the verification was commenced to that. Neither had the state been supplied with the affidavit of the accused, stating the facts on the basis of his applications, and the state in any case, he fitly entitled to ask for a postponement to declare itself. The worship by the state is in possession of the document by uninformed by the investigating officer Colonel John, a medical doctor, and she states her qualifications there at the bottom of the document. In the case the court does not have a copy of it available, I can supply it with the safety qualifications, medical practice number, and she indicated what she sees, what is the provisional diagnosis of the accused. That would substantiate the state allegation with the definition that the accused should be referred for 30 days observation to Under the circumstances, I cannot see that the accused can actually be consulted with and a proper statement can be taken from him. We may never get to the stage where the accused can ever be charged with the offence. If Falkenberg says that the accused was not conscious in interest, that would be the end of the matter. Why go into a protracted bail application? Put evidence before the court, containing the circumstances of the accused and his version of the events. If Falkenberg says the accused was not conscious in interest at the time of the commission of the offence. So the state is adamant, firstly, that the matter was not set down for the bail application. Secondly, that the defence didn't provide the state of the document setting on their version of the bail application. And thirdly, it would be a total waste of time to go into a bail application if Falkenberg indicates that the accused was not conscious in interest in the state. There is the onus to prove that. So why waste time to bail application? We do not want at a later stage, if the matter is set down for trial, to find out in the middle of the trial that the accused is not conscious in interest. The court observed this morning the behavior of the accused. He turned around, he appeared to be confused, he should have concentrated recognition of the fact.
Let me find the letter, doctor.
As the court reasons.
What about the fact that the state that they want that the court has been subjected to fire and they argue that they received it between only
Bail application. Oh, fight the rest of the argument from the as the court reasons. The bail application, as the court reasons.
and they need to consult with the
My apologies to my understanding.
not for bail application, for defense to have a consultation with the accused.
Okay.
In the next how many years?
I'm not quite sure. As I say, I think the indication that it will be it won't be long, because what Your Worship, if I may, with your permission, just explain where we are with this meeting. The state, with the greatest respect to Melanie Friend, is now playing a very disingenuous game. Because on the one, they want to sit on two stools. On the one hand, they furnish the court with documents which are clearly intended to put the matter under a particular schedule in relation to a bail application, because they know very well that that's what was written in the document. On the other hand, they now want to argue that the matter was not postponed in terms of Section 50, when it clearly was. And Your Worship, this is a serious matter. The state cannot continue playing a double game. On the one hand, on the 3rd of January, they had the so-called medical certificate. And yet they came to court on the 4th. And they continued, they went to his home in the northwest and did all that. Now we're told that they might not even be, it might be a waste of time to continue. So while they are continuing with their investigations and tarnishing the image and name of the accused, they want to play the other game that says, well, it might be that the outcome of the psychiatric observation does not even necessitate a trial. So which is which? They must either adopt that attitude or continue with their investigations that they've been doing apace for the past 7 days. But all that, Your Worship, I will argue the matter after the end of the consultation and what will happen next. But all I'm saying, Your Worship, is that we are here for one purpose and one purpose only. Whether this man should remain in police custody for the duration of a further period. He's now been in for about 10 days or more, and whether he should do that. And that is purely a matter about the liberty of the individual. Whatever his health condition might be, he's still a human being, and he must be either lawfully incarcerated or not lawfully incarcerated. And we cannot have these delaying tactics and kicking for touch, ask for 7 days, then after the 7 days, ask for another 30 days, and so on. All that is all very well, but the person is sitting in a jail cell and is presumed to be innocent. But we will address the worship fully at the correct time.
There is a prima facie evidence form that might not be to stand trial. The matter just to make the look at the which is proof that they can prove your fit to stand trial, including calling the doctor that so we are facing two aspects here. Whether we have to be or we proceed to require a terms to determine the status of the So in short, it's confident to know this medical evidence is seen and the state to the proof what they are creating. But in proof of probability, now the prima facie evidence that might not be
what in general, get up
this document has come before the court on the basis we know regulated by the when there's such a suspicion that the person must be there. So the state has produced a prima facie evidence form.
She has been
Yes, Your Worship, again, I will address that when we get back. But for now, I just would say maybe during the break, refer Your Worship to Section 79 of the Criminal Procedure Act. Your Worship correctly points out that the matter is governed by that section. And just indicate that, firstly, we, just a correction, Your Worship, the only thing that is before Your Worship now is not anything other than something that says that is a recommendation for a referral for a 30-day observation. That's all. Your Worship is then empowered in those circumstances to act in terms of Section 79(2), which says the court may, obviously depending on the evidence, as you correctly say, Your Worship, if they establish even the prima facie case, refer the accused, commit the accused to a psychiatric hospital or to any other place designated by the court for such periods not exceeding 30 days. That's where the 30 days comes from. As the court may from time to time determine, and when accused is in custody, when he is so committed, he shall, while he is so committed, be deemed to be in the lawful custody of the person or the authority in whose custody he was at the time of such committal. Then says, when the period of the committal is for the first time extended under section, okay. Now, and subsection C, the court may make the following orders after inquiry referred in the subsection. And I want to refer Your Worship specifically to sub-Roman 3. Make any order it deems fit regarding the custody of the accused. So even if there was prima facie evidence, the court would still have a discussion as to what should happen in the meantime to the accused. But we will address all those issues in due course, Your Worship. If we can then be granted the opportunity to consult, because as it happens, the accused person has not had any insight into any of these things for the reasons that I've explained. As God pleases. And we'll also take the opportunity to engage our colleagues. Yes, let's take everything.